and having to tell her that other 9-year-olds were just killed in a shooting is horrific.
This shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
To run enhanced background checks on young people under 21 trying to buy a firearm.
California has some of the nation's strongest laws regulating the sale of ammunition, and in 2019 became the first state in the nation to require a point-of-sale background check to buy ammunition. Sales and transfer of ammunition. In 2016, California voters passed Proposition 63, which aimed to regulate ammunition sales in the state. Since January 1, 2018, individuals selling more than 500 rounds of ammunition per month are required to obtain a state-issued business license called an ammunition vendor license and conduct ammunition sales at specified business locations or gun shows. Licensees are automatically deemed licensed ammunition vendors if they comply with legal requirements. Once licensed, ammunition vendors must report the loss or theft of ammunition to law enforcement and obtain a certificate of eligibility from employees handling or selling ammunition. Ammunition sales must generally be conducted by licensed vendors, similar to California law governing the sale and transfer of firearms. Unlicensed sellers must process ammunition through a licensed vendor, and ammunition obtained over the internet or from out of state must be initially shipped to a licensed vendor for physical delivery to the purchaser. Since July 1, 2019, licensed ammunition vendors must record, maintain, and report to the DOJ records of ammunition sales, similar to dealers' record of sales for firearms purchases. The California DOJ is required to maintain a database of these sale records. State law allows people to sell or share ammunition with their spouses, domestic partners, parents, grandparents, children, and grandchildren without the participation of a licensed vendor. It also allows people to buy ammunition at a shooting range without undergoing a background check and without a sales record as long as they keep the ammunition inside the facility. California prohibits supplying ammunition to anyone they know or reasonably should know is prohibited from possessing ammunition, and it makes it illegal for a person to supply ammunition to a straw purchaser with knowledge or cause to believe that the straw purchaser would subsequently provide it to a prohibited person. California ammunition regulations and liability. California law prohibits people from owning, possessing, or having custody or control of ammunition or reloaded ammunition if they fall into any of the categories of people ineligible to purchase or possess firearms under state law. Additionally, California law prohibits people from possessing ammunition if they are subject to a court injunction related to activity as a member of a criminal street gang. The minimum age to possess ammunition is 18 years, except if the minor has the written consent of a parent or legal guardian to possess live ammunition, is accompanied by a parent or legal guardian, or is actively engaged in a lawful recreational sport that involves the use of a firearm. Sellers of ammunition are also generally prohibited from selling any ammunition to a person under 18 years of age and from selling handgun ammunition to a person under 21. California prohibits ammunition from being displayed at gun shows except in closed containers, unless the seller is showing the ammunition to a prospective buyer. No person at a gun show in California can possess both a firearm and ammunition designed to be fired in the firearm. Vendors selling such items at the show are exempt.
Because they like the outcome of the policy, the banning of a piece of plastic.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
Obviously, they're gone, but will be an inspiration for us to do more. I'm not going to sign this bill into law.
Circuit decision in U.S. v. Rahimi is worth highlighting. As others have noted, the panel struck down a federal statute.
California also bans the manufacture, importation, sale, offer for sale, or knowing possession or transportation of handgun ammunition designed primarily to penetrate metal or armor. This ban applies to any ammunition except a shotgun shell or ammunition primarily designed for use in rifles that is designed primarily to penetrate a body vest or body shield, either by virtue of its shape, cross-sectional density, or coating, or because it has a projectile or projectile core constructed entirely of tungsten alloys, steel, iron, brass, beryllium copper, or depleted uranium, or any equivalent material of similar density or hardness. California also prohibits the manufacture, importation, keeping or offering for sale, transfer or possession of any flechette dart or bullet that contains an explosive agent. Additionally, California generally prohibits any person, firm, or corporation from selling, offering for sale, possessing, or knowingly transporting any fixed ammunition greater than .60 caliber. In 2022, California enacted some of the nation's strongest legislation to promote victims' and public officials' ability to bring civil lawsuits against the firearm and ammunition industry for illegal conduct that causes harm. The Firearm Industry Responsibility Act, which takes effect on July 1, 2023, requires people and companies to comply with a firearm industry standard of conduct when engaged in the sale, manufacture, distribution, marketing, or other conduct related to commerce in firearms, ammunition, and related products in or affecting California. The law also makes it unlawful to manufacture, market, import, or offer for wholesale or retail sale any ammunition that is abnormally dangerous and likely to cause an unreasonable risk of harm to public health and safety in California. California has 100+ gun laws. California bans guns for domestic violence offenders. It bans them for people deemed a danger to others or themselves. There is a ban on large-capacity magazines and a ban on noise-muffling silencers. Semi-auto guns of the sort colloquially known as attack weapons are famously banned. More than 100 gun laws, the most of any state, are on the books in California. They have saved lives, policymakers say. Californians have among the lowest rates of gun slaying in the U.S. Yet those laws failed to stop the mass slaying of at least 19 people in back-to-back mass slayings. The tragedies in Monterey Park and Half Moon Bay have confounded Americans, who regard California as a best-case bastion of gun safety in a nation awash with firearms. Inside the state, gun rights proponents say the shootings show that California's strategy is a failure. Gun safety groups, meanwhile, have already begun mobilizing for more laws and better enforcement. As details emerge in the investigations, numerous shortcomings have been highlighted, even with California's voluminous law.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
For instance, the state's regulatory net does not necessarily force gun owners to relinquish weapons that were legal for them to buy in the past, but now are banned. California cannot remove guns from people who may have exhibited dangerous behavior but aren't properly flagged to courts or law enforcement. And the state must contend with the illegal gun trade, a river of unregistered ghost guns, and the flow of firearms from neighboring states with less strict regulations. More broadly, however, the shootings are offering a lesson in the limits of state power to stop American gun violence, even with the political will at all levels of the state government to do so. Recent U.S. Supreme Court decisions have thrown key California laws into question, and the most recent shootings themselves have highlighted the difficulty of using state law to balance safety and liberty. Gun control and California shootings. San Mateo County's District Attorney Steve Wagstaff expressed his displeasure, saying that he has been following efforts to restrict access to firearms for years and is disheartened by the lack of results. Although California has put in place some beneficial laws, he stated that there is still opportunity for improvement. There were 11 fatalities and 8 wounded from a slaying at a ballroom dance studio in Monterey Park. Hu Can Tran, 72, is the suspect who is accused of opening fire at a Lunar New Year party. After being caught by police near the van he had used to flee, the suspect committed self-hurt. Hours after an outbreak of workplace violence at 2 plant nurseries, Zhao Chun-Li, 66, was detained by sheriff's officers in Half Moon Bay 2 days later. Both alleged gunmen had run-ins with the law in the past. Both seemed to be experiencing a mental health crisis. Additionally, both had strictly controlled guns that are illegal to purchase in California without a number of protections. However, despite California's overlapping public safety and health standards, which are put in place to reduce the danger of gun slayings, both managed to get through them. The semi-auto Cobra M11-9 pistol that the slayer in Monterey Park used, along with its 30-round mag and what seemed to be a homemade suppressor wrapped in duct tape, is forbidden to buy or sell in California. The firearm, which was made in the 1970s and 80s, is categorized as an attack weapon by the state because it has a barrel that seems to be threaded, an unlawful suppressor, and the capability to receive a detachable mag. However, according to the authorities, Mr. Tran bought the handgun in Monterey Park in 1999. Sheriff Robert Luna of Los Angeles County said the pistol was not registered in the state but did not say how he got it. Licensed stores in California stopped selling the weapon decades ago. High-capacity mag sales, production, and import have all been largely prohibited in California since 2000. But if Mr. Tran had purchased it before it was banned, or during a 7-day window in 2019, experts on gun rights say it might have been permissible. The exception was made as a result of Judge Roger T. Benitez of the U.S. District Court for the Southern District of California, a federal judge who is well known for opposing state gun laws. Benitez once compared the AR-15 assault rifle, which has been used in many mass slayings, to a Swiss Army knife, saying that they are both a perfect combination of home defense weapons and homeland defense equipment. Judge Benitez eventually issued a stay of his own decision that the state mag ban violated the Second Amendment, pending an appeal, but in the interim, sales of large-capacity mags skyrocketed throughout the state. Gun laws and enforcement in California. In order to stop the sale of firearms to those who might hurt both themselves and others, California additionally enforces stringent background checks. Criminal offenses result in a lifetime ban on gun ownership, while some misdemeanor convictions might result in a 10-year ban. Sheriff Luna reported that Mr. Tran had been detained for illegal handgun possession in 1990. Police are still looking into how he acquired his firearms, and it is unknown if he was ever found guilty. Pistol law experts claimed that if Mr. Tran had not been officially charged or found guilty, or had just been found guilty of a non-violent misdemeanor and had served his probation, California's rules would not have barred him from legally purchasing a pistol. A former flatmate of the suspected shooter successfully applied for a temporary restraining order in Half Moon Bay in 2013, on the grounds that Mr. Zhao had threatened to take his life and attempted to choke him. However, Mr. Zhao claimed to have legally purchased the Ruger semi-auto in California 2 years prior, according to the investigators, and had used it in Half Moon Bay. Investigators, according to Mr. Wagstaff, are still trying to figure out how and where he got the gun.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
Well, I'm sure it's enormously high. It's 36 per 100,000 people.
I just felt that I needed to be able to protect myself.
In California, restraining orders can make someone unable to buy firearms. However, according to court documents, the injunction against Mr. Zhao was only temporary and ended in July 2013. Additionally, California has a red flag statute that enables law enforcement, family members, employers, co-workers, and others to ask a court for a gun violence restraining order to have firearms taken away from those who may pose a threat to themselves or others. But if no one follows the laws, they're useless. Nearly 1,400 gun violence restraining orders were granted in the state in 2021, up from 85 in 2016. But according to experts, that law is an underutilized tool. In spite of the fact that California has had access to gun violence restraining orders for 5 years, according to a 2021 study by the Violence Prevention Research Program at the University of California, Davis, 2/3 of the state's residents have never heard of them. The program's director, Dr. Garen J. Wintemute, claimed that many mass slayers give away their intentions beforehand or leave clues in their planning. According to study, 1 in 8 persons in California at any given moment are aware of at least one person they would think would harm someone else or themselves, he claimed. One example could be the city of San Diego, where Mara Elliott, the city attorney, had asked for more than 1,000 restraining orders against gun violence since 2017. The city successfully petitioned for and obtained the confiscation of a gun from a person who had made threats to harm people at a nearby hospital. Ms. Elliott claims that residents of Monterey Park have improved their vigilance and proactiveness in alerting authorities to any suspicious behavior. People are increasingly aware of how critical it is to call to report suspected threats or events, she said. Mr. Tran, the suspect in the Monterey Park shooting, was characterized as a resentful, paranoid, and socially isolated person in court documents and by associates. 2 weeks before the slaying, Mr. Tran went to the police station in Hemet, California, where he lived, to make flimsy accusations of being the victim of fraud and theft, as well as claims that his family had previously tried to poison him. In relation to the Half Moon Bay slaying, Mr. Zhao, the alleged shooter, claimed that he was not mentally stable at the time of the occurrence in a jailhouse interview with NBC Bay Area. He said he had endured years of being treated unfairly at work. Authorities acknowledged that the supervisor who charged Mr. Zhao $100 for a forklift mishap appeared to be the catalyst for his alleged act of violence. But neither man seems to have worried anyone to the point where they would need a court order to have their firearms taken away. They claimed that their neighbors and friends were unaware that they were violent, self-harming, or armed. Political responses in California. According to official gun homicide data examined by the advocacy organization Everytown for Gun Safety, victims of mass slayings make up roughly 1% of all gun slayings in the U.S. According to a recent study by the Independent Public Policy Institute of California, the likelihood of ending in a mass slaying is much lower in California. Across the country, little over half of all gun slayings are caused by self-hurt. However, officials claim that what mass casualty events lack in numbers, they frequently make up for in terror and cries for political action. Following the mass endings in Uvalde, Texas and Buffalo, New York last year, California accelerated the adoption of more than a dozen new gun regulations. Sam Berettas, executive director of Gun Owners of California, claims that proponents of gun control contend that passing further regulations is not the way to ensure safety because mass slayings are already prohibited. Berettas challenges the value of making existing unlawful behavior even more unlawful. A legislative working group on the prevention of gun violence, co-chaired by California State Assembly Democrat Jesse Gabriel, has announced that its meeting has been moved earlier to explore possible new gun violence legislation. The proposed laws include enacting a state excise tax on firearms and ammunition.
I don't have a gun, but I don't give a damn about anybody else having one.
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
What changed is that that item that was submitted was not produced and was not the item that was marketed.
The government quite properly charged him with several crimes.
Extending the 3-year gun ownership ban for people who have domestic violence restraining orders against them, making it illegal to possess unregistered ghost guns, and enabling people who are going through a mental health crisis to add their names to a do not sell list. Additionally, initiatives are being made to raise awareness of restraining orders against gun violence. Jesse Gabriel also said that a bill was being created to bring the state's concealed carry permit rules into compliance with a recent Supreme Court decision that invalidated gun control legislation in multiple states, including California. Numerous legal challenges to California's gun laws, such as the prohibitions on assault-style weapons and high-capacity magazines, are pending Judge Benitez's decision as a result of the ruling. The California Attorney General Rob Bonta emphasizes the significance of tightening gun laws and modifying concealed carry laws. Bonta recognizes the potential need for fresh techniques and inquires as to if there are any novel ideas that have been considered before. Rohde versus Bonta, California's ammunition ban case. The case involving California's ammunition ban is known as Rohde versus Bonta. California gun owners have been eagerly awaiting updates on this case since February, when Judge Benitez became relatively quiet on Rohde, as well as the two other significant cases, Duncan and Miller. Duncan pertains to California's magazine ban, while Miller deals with the state's ban on so-called assault weapons. However, last week, we received an order from Judge Benitez scheduling a consolidated validation hearing for the Rohde case. This law, passed through Proposition 63, requires ammunition purchasers to undergo 1 or 2 background checks to ensure legal eligibility. There is a basic eligibility check and a standard eligibility check, each with its own fee. Additionally, California restricts the direct shipment of ammunition to individuals unless they possess a COE or FFL03. Although there are some exceptions, these laws apply to the majority of California citizens. The central challenge in the Rody v. Bonta case revolves around the question law in California, specifically addressing the ability to purchase ammunition online and have it shipped directly to one's home. Judge Roger T. Benitez, also known as Judge Benitez, is the district court judge who initially reviewed the case and ruled on the preliminary injunction. Judge Benitez's decision. In this case, Judge Benitez employed a version of the text informed by history and tradition to establish the simple Heller test. Applying this test, he found that California's background check laws, which effectively hindered law-abiding citizens from purchasing common ammunition, were unconstitutional. Judge Benitez emphasized that under the simple Heller test, the review could conclude at this initial step without further analysis. Additionally, he noted that an ammunition background check lacks historical precedent and has never been implemented before now. After granting the preliminary injunction, a brief period known as Ammo Day occurred in California, when the injunction was in effect for approximately 24 hours. Subsequently, the state of California appealed the decision to the Ninth Circuit. Oral arguments were held in November 2020 in front of a 3-judge panel. However, the ruling of that panel was put on hold following the Bruin decision. The panel in Rody then requested supplemental briefs from the parties to assess the impact of the Bruin decision on this specific case. In their briefs, the state of California initially argued that the Bruin decision had no effect on the case, since they claimed that ammunition restrictions in the state do not implicate conduct protected by the Second Amendment. However, they also proposed that if the panel found a right to purchase ammunition under the Second Amendment, the case should be remanded back to Judge Benitez for reconsideration in light of the Bruin decision. Consequently, the case was returned to Judge Benitez for him to rule once again, taking into account the Bruin decision. He was tasked with determining whether to grant a preliminary injunction or not based on the new information. Preliminary injunction and trial in gun cases. At the beginning of December, the Miller, Duncan, Rody, and Fouts cases were consolidated and brought before Judge Benitez. During the conference, Judge Benitez instructed the state of California to provide a spreadsheet of enacted laws and regulations related to the cases within 30 days. The plaintiffs were then given 30 days to respond to those examples, and both parties were granted an additional 10 days to file replies. This resulted in a holding pattern for 70 days until the final documents were submitted in February. Recently, Judge Benitez broke his silence and issued an order specifically for the Rody case. In the order, he scheduled a consolidated hearing on the motion for a preliminary injunction and also designated the same hearing as a trial on the merits of the case. This means that the hearing will cover both the request for a preliminary injunction and the actual trial on the merits simultaneously. The order states that the hearing on the motion for a preliminary injunction will take place on Monday, July 17, 2023, at 2 p.m. in Courtroom 5A. According to the Federal Rules of Civil Procedure, Judge Benitez intends to consolidate the hearing with the trial on the merits. The parties are expected to address various topics during the hearing, including the plaintiff's standing, whether the plaintiff's conduct is protected by the Second Amendment, the relevance of historical analogs, and footnote 9 in New York State Rifle and Pistol Association v. Bruin, the Dormant Commerce Clause, preemption under 18 U.S.C. Section 926A, the impact of laws produced by ballot measure Proposition 63, and whether further discovery is necessary. In this case, the possibility of a preliminary injunction may become unnecessary if Judge Benitez determines after the hearing that no further discovery or fact-finding is needed and prefers to rule based on the presented briefs and arguments, effectively concluding the case. This suggests that Judge Benitez is nearing the end of these cases and no longer wishes to prolong them during the preliminary injunction stage. Instead, he aims to elevate the case to the Ninth Circuit Court for a final resolution, shifting the responsibility to them. This also advances the case in the appeals process, allowing for a final judgment rather than an interim decision on the appropriateness of a preliminary injunction. Notably, if the case reaches the Supreme Court, it will be decided on its merits rather than the question of a preliminary injunction. The Duncan versus Becerra magazine ban case has also garnered attention, but there are concerns that it may face a similar fate. It is possible that Duncan could be entangled in the situation for a longer period. However, it's important to note that this issue may only be relevant to the Rhodey case, and Judge Benitez's actions could be specific to this particular instance, considering the dynamic nature of Proposition 63. It is intriguing to see this decision unfold, as it combines the hearing for a preliminary injunction with the merits hearing. Many California gun owners will undoubtedly closely follow the hearing scheduled for July 17th. This brief update provides some interesting information on the Rhodey versus Becerra ammo ban case for those interested in the current developments in California. That's all for this video, folks. Thank you so much for watching, and we will see you next time.